Part 4. Rights of Workers. Within the broad context of human rights. While work in all its many senses is an obligation, that is to say, a duty, it is also a source of rights on the part of the worker. These rights must be examined in the broad context of human rights as a whole, which are connatural with man, and many of which are proclaimed by various international organizations and increasingly guaranteed by the individual states for their citizens. Respect for this broad range of human rights constitutes the fundamental conditions for peace in the modern world. Peace both within individual countries and societies and in international relations, as the Church's magisterium has several times noted, especially since the encyclical Pacem in Terris. The human rights that flow from work are part of the broader context of those fundamental rights of the person. However, within this context, they have a very specific character corresponding to the specific nature of human work as outlined above. It is in keeping with this character that we must view them. Work is, as has been said, an obligation, that is to say, a duty on the part of man. This is true in all the many meanings of the word. Man must work, both because the Creator has commanded it and because of his own humanity, which requires work in order to be maintained and developed. Man must work out of regard for others, especially his own family, but also for the society he belongs to, the country of which he is a child, and the whole human family of which he is a member, since he is the heir to the work of generations and at the same time a sharer in the building of the future of those who will come after him in the succession of history. All this constitutes the moral obligation of work, understood in its wide sense. When we have to consider the moral rights corresponding to this obligation of every person with the regard to work, we must always keep before our eyes the whole vast range of points of reference in which the labor of every working subject is manifested. For when we speak of the obligation of work and of the rights of the worker that correspond to this obligation, we think in the first place of the relationship between the employer, direct or indirect, and the worker. The distinction between the direct and indirect employer is seen to be very important when one considers both the way in which labor is actually organized and the possibility of the formation of just or unjust relationships in the field of labor. Since the direct employer is the person or institution with whom the worker enters directly into a work contract in accordance with definite conditions, we must understand, as the indirect employer, many different factors, other than the direct employer, that exercise a determining influence on the shaping both of the work contract and, consequently, of just or unjust relationships in the field of human labor. Direct and indirect employer. The concept of indirect employer includes both persons and institutions of various kinds, and also collective labor contracts and the principles of conduct which are laid down by these persons and institutions, and which determine the whole socio-economic system, are its result. The concept of indirect employer thus refers to many different elements. The responsibility of the indirect employer differs from that of the direct employer. The term itself indicates that the responsibility is less direct, but it remains a true responsibility. The indirect employer substantially determines one or other facet of the labor relationship, thus conditioning the conduct of the direct employer when the latter determines in concrete terms the actual work contract and labor relations. This is not to absolve the direct employer from his own responsibility, but only to draw attention to the whole network of influences that condition his conduct. When it is a question of establishing an ethically correct labor policy, all these influences must be kept in mind. A policy is correct when the objective rights of the worker are fully respected. The concept of the indirect employer is applicable to every society, and in the first place to the state. For it is the state that must conduct a just labor policy. However, it is common knowledge that in the present system of economic relations in the world, there are numerous links between individual states, links that find expression, for instance, in the import and export process, that is to say, in the mutual exchange of economic goods, whether raw materials, semi-manufactured goods, or finished industrial products. These links also create mutual dependence, and as a result, it would be difficult to speak in the case of any state, even the economically most powerful, of complete self-sufficiency or autarky. Such a system of mutual dependence is in itself normal. However, it can easily become an occasion for various forms of exploitation or injustice, and as a result, influence the labor policy of individual states. And finally, it can influence the individual worker, who is the proper subject of labor. For instance, the highly industrialized countries, and even more the businesses that direct on a large scale the means of industrial production, the companies referred to as multinational or transnational, fix the highest possible prices for their products, while trying at the same time to fix the lowest possible prices for raw materials or semi-manufactured goods. This is one of the causes of an ever-increasing disproportion between national incomes. The gap between most of the richest countries and the poorest ones is not diminishing or being stabilized, but is increasing more and more, to the detriment, obviously, of the poor countries. Evidently, this must have an effect on local labor policy and on workers' situations in the economically disadvantaged societies. Finding himself in a system thus conditioned, the direct employer fixes working conditions below the objective requirements of the workers, especially if he himself wishes to obtain the highest possible profits from the business which he runs, or from the businesses which he runs, in the case of a situation of socialized ownership of the means of production. It is easy to see that this framework of forms of dependence linked with the concept of the indirect employer is enormously extensive and complicated. It is determined, in a sense, by all the elements that are decisive for economic life within a given society and state, but also by much wider links and forms of dependence. The attainment of the workers' rights cannot, however, be doomed to be merely a result of economic systems, which on a larger or smaller scale are guided chiefly by the criterion of maximizing profit. On the contrary, it is respect for the objective rights of the worker, every kind of worker, manual or intellectual, industrial or agricultural, etc., that must constitute the adequate and fundamental criterion for shaping the whole economy, both on the level of the individual, society, and state, and within the whole of the world economic policy and of the systems of international relationships that derive from it. Influence in this direction should be exercised by all the international organizations whose concern it is, beginning with the United Nations Organization. It appears that the International Labor Organization and the Food and Agricultural Organization of the United Nations, and other bodies too, have fresh contributions to offer on this point in particular. Within the individual states, there are ministries or public departments and also various social institutions set up for this purpose. All of this effectively indicates the importance of the indirect employer, as has been said above, in achieving full respect for the workers' rights, since the rights of the human person are the key element in the whole of the social moral order. The employment issue. When we consider the rights of workers in relation to the indirect employer, that is to say, all the agents at the national and international levels that are responsible for the whole orientation of public policy, we must first direct our attention to a fundamental issue, the question of finding work, or, in other words, the issue of suitable employment for all who are capable of it. The opposite of a just and right situation in this field is unemployment. That is to say, the lack of work for those who are capable of it. It can be a question of general unemployment or of unemployment in certain sectors of work. The role of the agents included under the title of indirect employer is to act against unemployment, which in all cases is an evil, and which, when it reaches a certain level, can become a real social disaster. It is particularly painful when it especially affects young people, who, after appropriate cultural, technical, and professional preparation, fail to find work, and see their sincere wish to work and their readiness to take on their own responsibility for the economic and social development of the community sadly frustrated. The obligation to provide unemployment benefits, that is to say, the duty to make suitable grants indispensable for the subsistence of unemployed workers and their families, is a duty springing from the fundamental principle of the moral order in this sphere, namely the principle of the common use of goods, or, to put it in another and still simpler way, the right to life and subsistence. In order to meet the danger of unemployment and to ensure employment for all, the agents defined here as indirect employer must make provision for overall planning with regard to the different kinds of work by which not only the economic life, but also the cultural life of a given society is shaped. They must also give attention to organizing that work in a correct and rational way. In the final analysis, this overall concern weighs on the shoulders of the state, but it cannot mean one-sided centralization by the public authorities. Instead, what is in question is a just and rational coordination within the framework of which the initiative of individuals, free groups, and local work centers and complexes must be safeguarded, keeping in mind what has been said above with regard to the subject character of human labor. The fact of the mutual dependence of societies and states and the need to collaborate in various areas mean that, while preserving the sovereign rights of each society and state in the field of planning and organizing labor in its own society, action in this important area must also be taken in the dimension of international collaboration by means of the necessary treaties and agreements. Here, too, the criterion for these pacts and agreements must more and more be the criterion of human work considered as a fundamental right for all human beings, work which gives similar rights to all those who work, in such a way that the living standard of the workers in the different societies will less and less show these disturbing differences, which are unjust and are apt to provoke even violent reactions. The international organizations have an enormous part to play in this area. They must let themselves be guided by an exact diagnosis of the complex situations and of the influence exercised by natural, historical, civil, and other such circumstances. They must also be more highly operative with regard to plans for action jointly decided on. That is to say, they must be more effective in carrying them out. In this direction, it is possible to actuate a plan for universal and proportionate progress by all, in accordance with the guidance of Paul VI's encyclical Populorum Progressio. It must be stressed that the constitutive element in this progress, and also the most adequate way to verify it in the spirit of justice and peace, which the Church proclaims and for which she does not cease to pray to the Father of all individuals and of all peoples, is the continual reappraisal of man's work, both in the aspect of its objective finality and in the aspect of the dignity of the subject of all work, that is to say, man. The progress in question must be made through man and for man, and it must produce its fruit in man. A test of this progress will be the increasingly mature recognition of the purpose of work, and increasingly universal respect for the rights inherent in work in conformity with the dignity of man, the subject of work. Rational planning and the proper organization of human labor in keeping with individual societies and states should also facilitate the discovery of the right proportions between the different kinds of employment, work on the land, in industry, and the various services, white-collar work and scientific or artistic work, in accordance with the capabilities of individuals and for the common good of each society and of the whole of mankind. The organization of human life in accordance with the many possibilities of labor should be matched by a suitable system of instruction and education, aimed first of all at developing mature human beings, but also aimed at preparing people specifically for assuming a good advantage in appropriate place in the vast and socially differentiated world of work. As we view the whole human family throughout the world, we cannot fail to be struck by a disconcerting fact of immense proportions. The fact that, while conspicuous natural resources remain unused, there are huge numbers of people who are unemployed or underemployed, and countless multitudes of people suffering from hunger. This is a fact that without any doubt demonstrates that both within the individual political communities and in their relationships on the continental and world level, there is something wrong with the organization of work and employment, precisely at the most critical and socially important points. Wages and other social benefits. After outlining the important role that concern for providing employment for all workers plays in safeguarding respect for the inalienable rights of man in view of his work, it is worthwhile taking a closer look at these rights, which in the final analysis are formed within the relationship between worker and direct employer. All that has been said above on the subject of the indirect employer is aimed at defining these relationships more exactly, by showing the many forms of conditioning within which these relationships are indirectly formed. The consideration does not, however, have a purely descriptive purpose. It is not a brief treatise on economics or politics. It is a matter of highlighting the deontological and moral aspect. The key problems of social ethics in this case is that of just remuneration for work done. In the context of the present, there is no more important way for securing a just relationship between the worker and the employer than that constituted by remuneration for work. Whether the work is done in a system of private ownership of the means of production, or in a system where ownership has undergone a certain socialization, that relationship between the employer, first and foremost the direct employer, and the worker is resolved on the basis of the wage, that is, through just remuneration for work done. It should also be noted that the justice of a socio-economic system and, in each case, its just functioning, deserve in the final analysis to be evaluated by the way in which man's work is properly remunerated in the system. Here we return once more to the first principle of the whole ethical and social order, namely, the principle of the common use of goods. In every system, regardless of the fundamental relationships within it between capital and labor, wages, that is to say, remuneration for work, are still a practical means whereby the vast majority of people can have access to those goods which are intended for common use, both the goods of nature and manufactured goods. Both kinds of goods become accessible to the worker through the wage which he receives as a remuneration for his work. Hence, in every case, a just wage is the concrete means of verifying the justice of the whole socio-economic system, and in any case, of checking that it is functioning justly. It is not the only means of checking, but it is a particularly important one, and in a sense, the key means. This means of checking concerns above all the family. Just remuneration for the work of an adult who is responsible for a family means remuneration which will suffice for establishing and properly maintaining a family and for providing security for its future. Such remuneration can be given either through what is called a family wage, that is, a single salary given to the head of the family for his work, sufficient for the needs of the family without the other spouse having to take up gainful employment outside of the home, or through other social measures, such as family allowances, or grants to mothers devoting themselves exclusively to their families. These grants should correspond to the actual needs, that is, to the number of dependents, for as long as they are not in a position to assume proper responsibility for their own lives. Experience confirms that there must be a social reevaluation of the mother's role, of the toil connected with it, and of the need that children have for care, love, and affection, in order that they may develop into responsible, morally and religiously mature, and psychologically stable persons. It will redound to the credit of society to make it possible for a mother, without inhibiting her freedom, without psychological or practical discrimination, and without penalizing her as compared with other women, to devote herself to taking care of her children and educating them in accordance with their needs, which vary with age. Having to abandon these tasks in order to take up paid work outside of the home is wrong from the point of view of the good of society and of the family when it contradicts or hinders these primary goals of the mission of a mother. In this context, it should be emphasized that on a more general level, the whole labor process must be organized and adapted in such a way as to respect the requirements of the person and his or her forms of life, above all in the home, taking into account the individual's age and sex. It is a fact that in many societies, women work in nearly every sector of life. But it is fitting that they should be able to fulfill their tasks in accordance with their own nature, without being discriminated against and without being excluded from jobs for which they are capable, but also without lack of respect for their family aspirations and for their specific role in contributing, together with men, to the good of society. The true advancement of women requires that labor should be structured in such a way that women do not have to pay for the advancement by abandoning what is specific to them and at the expense of the family, in which women as mothers have an irreplaceable role. Besides wages, various social benefits intended to ensure the life and health of workers and their families play a part here. The expenses involved in healthcare, especially in the case of accidents at work, demand that medical assistance should be easily available for workers, and that as far as possible, it should be cheap or even free of charge. Another sector regarding benefits is the sector associated with the right to rest. In the first place, this involves a regular weekly rest comprising at least Sunday, and also a longer period of rest, namely the holiday or vacation taken once a year or possibly in several shorter periods during the year. A third sector concerns the right to a pension and to insurance for old age in the case of accidents at work. Within the sphere of these principal rights, there develops a whole system of particular rights, which together with remuneration for work determine the correct relationship between worker and employer. Among these rights, there should never be overlooked the right to a working environment and to manufacturing processes which are not harmful to the worker's physical health or to their moral integrity. Importance of unions. All these rights, together with the need for the workers themselves to secure them, give rise to yet another right, the right of association. That is, to form associations for the purpose of defending the vital needs of those employed in the various professions. These associations are called labor or trade unions. The vital interests of the workers are to a certain extent common for all of them. At the same time, however, each type of work, each profession, has its own specific character, which should find a particular reflection in these organizations. In a sense, unions go back to the medieval guilds of artisans, insofar as the organizations brought together people belonging to the same craft, and thus on the basis of their work. However, unions differ from the guilds on this essential point. The modern unions grew up from the struggle of the workers in general, but especially the industrial workers, to protect their just rights vis-à-vis the entrepreneurs and the owners of the means of production. Their task is to defend the existential interests of workers in all sectors in which their rights are concerned. The experience of history teaches that organizations of this type are an indispensable element of social life, especially in modern industrialized societies. Obviously, this does not mean that only industrial workers can set up associations of this type. Representatives of every profession can use them to ensure their own rights. Thus, there are unions of agricultural workers and of white-collar workers. There are also employers' associations. All, as has been said above, are further divided into groups or subgroups according to particular professional specializations. Catholic social teaching does not hold that unions are no more than a reflection of the class structure of society, and that they are a mouthpiece for a class struggle, which inevitably governs social life. They are indeed a mouthpiece for the struggle of social justice, for the just rights of working people in accordance with their individual professions. However, this struggle should be seen as a normal endeavor for the just good. In the present case, for the good which corresponds to the needs and merits of working people associated by profession, but it is not a struggle against others, even if, in controversial questions, the struggle takes on a character of opposition towards others. This is because it aims at the good of social justice, not for the sake of struggle or in order to eliminate the opponent. It is characteristic of work that it first and foremost unites people. In this consists its social power, the power to build a community. In the final analysis, those who work and those who manage the means of production or who own them must in some way be united in this community. In light of this fundamental structure of all work, in the light of the fact that, in the final analysis, labor and capital are indispensable components of the process of production in any social system, it is clear that even if it is because of their work needs that people unite to secure their rights, their union remains a constructive factor of the social order and solidarity, and it is impossible to ignore it. Just efforts to secure the rights of workers who are united by the same profession should always take into account the limitations imposed by the general economic situation of the country. Union demands cannot be turned into a kind of group or class egoism, although they can and should also aim at correcting, with a view to the common good of the whole of society, everything defective in the system of ownership of the means of production, or in the way these are managed. Social and socio-economic life is certainly like a system of connected vessels, and every social activity directed towards safeguarding the rights of a particular groups should adapt itself to this system. In this sense, union activity undoubtedly enters the field of politics, understood as prudent concern for the common good. However, the role of unions is not to play politics in the sense that the expression is commonly understood today. Unions do not have the character of political parties struggling for power. They should not be subjected to the decision of political parties, or have too close links with them. In fact, in such a situation, they easily lose contact with their specific role, which is to secure the just rights of the workers within the framework of the common good of the whole of society. Instead, they become an instrument used for other purposes. Speaking of the protection of the just rights of workers according to their individual professions, we must of course always keep in mind that which determines the subjective character of work in each profession. But at the same time, indeed before all else, we must keep in mind that which conditions the specific dignity of the subject of the work. The activity of union organizations opens up many possibilities in this respect, including their efforts to instruct and educate the workers, and to foster their self-education. Praise is due to the work of the schools, what are known as workers' or people's universities, and the training programs and courses which have developed and are still developing this field of activity. It is always to be hoped that thanks to the work of their unions, workers will not only have more, but above all, be more. In other words, that they will realize their humanity more fully in every respect. One method used by unions in pursuing the just rights of their members is the strike, or work stoppage, as a kind of ultimatum to the competent bodies, especially the employers. This method is recognized by Catholic social teaching as legitimate in the proper conditions and within just limits. In this connection, workers should be assured the right to strike, without being subjected to personal penal sanctions for taking part in a strike. While admitting that it is a legitimate means, we must at the same time emphasize that a strike remains in a sense an extreme means. It must not be abused. It must not be abused especially for political purposes. Furthermore, it must never be forgotten that when essential community services are in question, they must in every case be ensured, if necessary, by means of appropriate legislation. Abuse of the strike weapon can lead to the paralysis of the whole of socio-economic life, and this is contrary to the requirements of the common good of society, which also corresponds to the properly understood nature of work itself. Dignity of agricultural work. All that has been said thus far on the dignity of work, on the objective and subjective dimension of human work, can be directly applied to the question of agricultural work and to the situation of the person who cultivates the earth by toiling in the fields. This is a vast sector of work on our planet, a sector not restricted to one or other continent, nor limited to the societies which have already attained a certain level of development and progress. The world of agriculture, which provides society with the goods it needs for its daily sustenance, is of fundamental importance. The conditions of the rural population and of agricultural work vary from place to place, and the social position of agricultural workers differs from country to country. This depends not only on the level of development of agricultural technology, but also, and perhaps more, on the recognition of the just rights of agricultural workers, and finally, on the level of awareness regarding the social ethics of work. Agricultural work involves considerable difficulties, including unremitting and sometimes exhausting physical effort, and a lack of appreciation on the part of society, to the point of making agricultural people feel that they are social outcasts, and of speeding up the phenomenon of their mass exodus from the countryside to the cities, and unfortunately to still more dehumanizing living conditions. Added to this are the lack of adequate professional training and of proper equipment, the spread of certain individualism, and also objectively unjust situations. In certain developing countries, millions of people are forced to cultivate the land belonging to others and are exploited by the big landowners without any hope of ever being able to gain possession of even a small piece of land of their own. There is a lack of forms of legal protection for the agricultural workers themselves and for their families in the case of old age, sickness, or unemployment. Long days of hard physical work are paid miserably. Land which could be cultivated is left abandoned by the owners. Legal titles to possession of a small portion of land that someone has personally cultivated for years are disregarded or left defenseless against the land hunger of more powerful individuals or groups. But even in the economically developed countries where scientific research, technological advancements, and state policy have brought agriculture to a very advanced level, the right to work can be infringed when the farm workers are denied the possibility of sharing in decisions concerning their services, or when they are denied the right to free association with a view to their just advancement socially, culturally, and economically. In many situations, radical and urgent changes are therefore needed in order to restore to agriculture and to rural people their just value as the basis for a healthy economy within the social community's development as a whole. Thus, it is necessary to proclaim and promote the dignity of work, of all work, but especially of agricultural work, in which man so eloquently subdues the earth he has received as a gift from God, and affirms his dominion in the visible world. The disabled person and work. Recently, national communities and international organizations have turned their attention to another question connected with work, one full of implications, the question of disabled people. They too are fully human subjects with corresponding innate, sacred, and inviolable rights. And in spite of the limitations and sufferings affecting their bodies and faculties, they point up more clearly the dignity and greatness of man. Since disabled people are subjects with all their rights, they should be helped to participate in the life of society in all its aspects and at all the levels accessible to their capacities. The disabled person is one of us and participates fully in the same humanity that we possess. It would be radically unworthy of man and a denial of our common humanity to admit to the life of the community and thus admit to work only those who are fully functional. To do so would be to practice a serious form of discrimination, that of the strong and healthy against the weak and sick. Work in the objective sense should be subordinated in this circumstance too to the dignity of man, to the subject of work, and not to economic advantage. Various bodies involved in the work of labor, both the direct and indirect employer, should therefore, by means of effective and appropriate measures, foster the right of disabled people to professional training and work, so that they can be given a productive activity suited to them. Many practical problems arise at this point, as well as legal and economic ones. But the community, that is to say, the public authorities, associations and intermediate groups, business enterprises, and the disabled themselves should pool their ideas and resources so as to attain this goal that must not be shirked, that disabled people may be offered work according to their capabilities. For this is demanded by their dignity as persons and as subjects of work. Each community will be able to set up suitable structures for finding or creating jobs for such people, both in the usual public or private enterprises, by offering them ordinary or suitably adapted jobs, and in what are called protected enterprises and surroundings. Careful attention must be devoted to the physical and psychological working conditions of disabled people, as for all workers, to their just remuneration, to the possibility of their promotion, and to the elimination of various obstacles. Without hiding the fact that this is a complex and difficult task, it is to be hoped that a correct concept of labor in the subjective sense will produce a situation which will make it possible for disabled people to feel that they are not cut off from the working world or dependent upon society, but that they are full-scale subjects of work, useful, respected for their human dignity, and called to contribute to the progress and welfare of their families and of the community according to their particular capacities. Work and the emigration question. Finally, we must say at least a few words on the subject of emigration in search of work. This is an age-old phenomenon which nevertheless continues to be repeated and is still today very widespread as a result of the complexities of modern life. Man has the right to leave his native land for various motives, and also the right to return, in order to seek better conditions of life in another country. This fact is certainly not without difficulties of various kinds. Above all, it generally constitutes a loss for the country which is left behind. It is a departure of a person who is also a member of a great community united by history, tradition, and culture, and that person must begin life in the midst of another society, united by a different culture, and very often by a different language. In this case, it is the loss of a subject of work, whose efforts of mind and body could contribute to the common good of his own country. But these efforts, this contribution, are instead offered to another society, which in a sense has less right to them than the person's country of origin. Nevertheless, even if emigration is in some respects an evil, in certain circumstances it is, as the phrase goes, a necessary evil. Everything should be done, and certainly much is being done to this end, to prevent this material evil from causing greater moral harm. Indeed, every possible effort should be made to ensure that it may bring benefit to the emigrant's personal, family, and social life, both for the country to which he goes and the country which he leaves. In this area, much depends on just legislation, in particular with regard to the rights of workers. It is obvious that the questions of just legislation enters into the context of the present considerations, especially from the point of view of these rights. The most important thing is that the person working away from his native land, whether as permanent emigrant or as a seasonal worker, should not be placed at a disadvantage in comparison with other workers in that society in the matter of working rights. Emigration in search of work must in no way become an opportunity for financial or social exploitation. As regards the work relationship, the same criteria should be applied to immigrant workers as to all other workers in the society concerned. The value of work should be measured by the same standard and not according to the difference in nationality, religion, or race. For even greater reason, the situation of constraint in which the emigrant may find himself should not be exploited. All these circumstances should categorically give way, after special qualification have of course been taken into consideration, to the fundamental value of work, which is bound up with the dignity of the human person. Once more, the fundamental principle must be repeated. The hierarchy of values and the profound meaning of work itself require that capital should be at the service of labor, and not labor at the service of capital.